Hello, my name is Ian Perry. I'm a lawyer and a graduate of the University of Mississippi for my JD and an LLM in aerospace law. Thank you to Michelle Hanlon and to the National Space Society for giving me the opportunity to speak today. I'll be discussing conflicts between the Outer Space Treaty and between the space treaties and current practice in outer space. This issue is a mess. In short, there is no way for a state which launches an object into outer space to rid itself of liability for that object after it has been launched. This is an issue that applies regardless of which treaty you look at, and I'll be discussing first how this applies with regard to just the surface level text of the treaties, and then I will go on in the middle part of the talk and discuss that and show that this is still the case when we look at subsequent interpretation and practice with regard to the treaties. And then briefly at the end, I will give some suggestions on how to resolve this issue. So when you look at Article 6 of the Outer Space Treaty, you see that states are supposed to be responsible for national activities in outer space, whether those are governmental or private activities, and that states are supposed to continually authorize and supervise all of their activities, including private actors. Now, when you look at Article 7, liability is assigned to a state which launches an object into outer space. And so we should take into account that when we look at the different languages involved in the treaties, some of the languages use the same word for both liability and responsibility. However, I think that really you get to liability regardless of whether you interpret those as distinct or as separate concepts. I think that these are separate. I think responsibility is not the same as liability, but in international arbitrations and international court cases, once a state is responsible for something that happens on Earth or in outer space or anywhere, it can be held liable for that. So it's summed up in the Chorzo factory case that reparation is the corollary of the breach of an obligation between states. So it really doesn't matter if you believe that those terms are equivalent or not, you can still get to liability. The problem is not so much that a subsequent purchasing state cannot be held liable. The problem is that the initial launching state remains liable indefinitely, no matter how attenuated its connection with the object. Now, according to standard treaty interpretation as summed up in the Vienna Convention on the Law of Treaties, you're supposed to attempt to avoid interpreting a treaty in a way which leads to manifest absurdity or unreasonableness. And so you can look at supplemental means of interpretation, such as the treaty negotiation documents, in an attempt to avoid that. However, when we look at the negotiation history of the Outer Space Treaty, which you can find in the Manual on Space Law, Volume 3, there is not a single mention in the entire negotiation of the treaty of a transfer of an object that had been launched in orbit, whether by sail or some other means. So it's simply not there. When we get to the Liability Convention, the problem is continued. The Outer Space Treaty did not use the term launching state, but the Liability Convention gets its definition of launching state by taking language from Article 7 of the Outer Space Treaty and then putting that in Article 1 of the Liability Convention. Now, when we get to Article 2, we have strict liability for any damage to the Earth for launching states. Article 3 maybe gives us a little bit of an out because it says states will only be liable for persons for whom they are responsible. So we might interpret this to mean that when an object is sold, those are persons for whom the state is no longer responsible. But the text of the treaty doesn't solve that issue for us, because you could simply think that if you sell an object to foreign nationals, well, then you're now responsible for those people. It really doesn't, just looking at the surface of the treaty, it doesn't resolve that issue. And even if we think that it allows us to that it allows for liability to shift for on-orbit damages, it doesn't tell us when that would happen. So it really leaves us without guidance as to which people were responsible for. A property interest is not the same as jurisdiction liability or responsibility. Brief definition of terms. Liability is something that can be is a penalty that can be incurred by a state. Responsibility is something that can be attributed to a state, and jurisdiction concerns state authority to act over persons or things. None of those The Liability Convention does not resolve how any of these things relate to on-orbit transfers, because like the Outer Space Treaty, it was simply not considered. You see this in Article 5. Liability is only considered in relation to the initial launching states. There's provision for agreements among those launching states. There's no provision for bringing another state into the activity. And if you look at the negotiation of the Liability Convention, it's the same story as the Outer Space Treaty. There's no discussion of on-orbit transfers, at least nothing made it into the records that we have. And when we look at ways out of this, we might think that registration would provide us a way out of it based off of analogies to the high seas and aviation, where you can have a flag that changes from state to state, or registration for an aircraft which can be shifted between states. And however, while the Outer Space Treaty's Article 8's provision on registration does tie registration to jurisdiction and control, it doesn't talk about a state which was not the initial launching state re-registering or being able to buy and transfer registration. There's just no discussion of that. Now, the registration convention is more detailed, but it doesn't save us from the problem. People negotiating the registration convention knew that there were going to be changes. There was one delegate talking about how joint launches or launches involving more than one state would become more common. You have one country, France, who's hoping that there would be a parallel national registration system which would act like a passport in space. The Japanese delegation's on record saying they wanted registration to work like flag on the high seas, or like registration for aircraft. But none of that really made it into the actual registration convention as we have it. Now, the first draft of the registration convention would have saved us quite a bit of trouble when it was submitted in 1968 by France. That very first draft of the registration did allow for transfers from the initial registering state to another service or to another state. That was cut out, and there's not really a lot of explanation as to why. It seems like people had other things on their mind. It doesn't appear to be very well considered, but unfortunately it was cut out, and we're left with the registration convention as we have it, which solely talks about the initial launching state, the state which launches, or group of states which launch, being able to agree among themselves. It doesn't say anything about this being binding on third parties, whereas flag on the high seas and registration of aircraft does have an effect on third parties. But it also says nothing about on-orbit subsequent purchasers or subsequent states coming in. It's all starting right at the beginning saying if there's multiple states involved in a launch, they can determine who registers it, but there's really no help to us within the registration convention. Now, the Vienna Convention on the Law of Treaties, again, summing up generally accepted practice, which is accepted by states, even the states that belong to it. It says that it's mandatory that you take into account how a treaty has been practiced, how it has been interpreted. You're not supposed to just take the text isolated from the subsequent context. And when you look at, say, international decisions, like the one I have up on the screen, which was a dispute between Nicaragua and Costa Rica, the court said this functions like a sort of tacit understanding. When you decide that the meaning has shifted of some clause in the treaty, there's a tacit agreement among the states involved to shift the meaning, or there may be a clause which it was understood would change in the interpretation might change because of shifting meanings in the law applied, and that's just a way of giving effect to the initial intent of the treaty. So when we look at the subsequent practice, we do find various principles that have been signed on by have been passed by the UN General Assembly. I'm not claiming that UN General Assembly resolutions are binding by themselves, but they do function as a way to see how the states, which are party to the Outer Space Treaty and the Liability Convention and the Registration Convention, have applied those and how they have agreed to interpret them. So when you look at the remote sensing principles, which were passed by the UN General Assembly in 1986, it talks about an operating state being responsible. So a state operating a object that's been launched is not, it doesn't say anything about the launching state. So I think it indicates that responsibility can shift from one state to another, but it doesn't help us with that problem of getting rid of liability. Now, a 1992 set of principles was passed by the UN General Assembly, and it looks like it might save us when you start reading it. It looks like it might provide a way to rationalize the law, but it doesn't. So it says for purposes of these principles, the state exercising jurisdiction at a particular point will be treated as the launching state. However, when we get to the next paragraph, the rug is jerked out from under us, and it says that For purpose of Principle 9, the definition of the term launching state there will apply. And unfortunately, Principle 9 is the principle on liability and compensation. And it just reaffirms the system of liability found in Outer Space Treaty Article 7 and in the Liability Convention. So it looks promising, but it doesn't help us with regard to making the initial launching state non-liable after a sale. Now, there was a resolution adopted by the General Assembly in 2004 on the launching state, but it simply advocates harmonizing different national laws, and advocates surveying national laws and harmonizing them, but doesn't give any suggestion as to how those laws should be harmonized. There is a 2007 recommendation on registration, and it does have one interesting thing where it says that when there's a change of supervision, the state of registration should work together with the state exercising responsibility under Article 6. So that confirms that the state which is exercising responsibility over the object might be different than the original launching state. So it confirms that new states can become liable, but it doesn't have any statement that registry itself can shift or that liability can shift. So those initial launching states are still on the hook, even though new states could potentially be liable. Now, in 2013, there was a set of recommendations passed which talk about a transfer of ownership or obligations. Now, that's interesting. It says obligations, but it doesn't define what obligations are being transferred. So it does not really save us as far as the irrational state of liability attaching to the initial launching state in an indefinite number of years down the road. Now, different states have responded to this in different ways. Some of them have taken affirmative acts to note that there has been a change with regard to satellites. So Sweden purchased a particular satellite, or a Swedish company purchased a particular satellite that had been launched from the territory of the United States by the United Kingdom, and that satellite had actually been registered by the United Kingdom. But Sweden went ahead and they registered it. They have a list of different satellites that they registered, and one of them was given a note saying bought in orbit in 1996. So they took care to differentiate that, but they still treated it as if it were a new registration. Now, China and the United Kingdom, when Hong Kong was transferred, there were a set of satellites which were transferred from the United Kingdom to the People's Republic of China, and both states on the same day sent a note verbal to the UN which said that the United Kingdom's one said that the UK was no longer the state of registry, and the People's Republic of China's note verbal on the same day said that the People's Republic of China was now the state of registry. Both said that the satellites had changed registry on July 1st, 1997, which was the day that Hong Kong was officially handed over. Now, in a weirder situation, in a case where Dutch nationals had actually procured the launching of a satellite, Dutch nationals had been involved with the launch from the beginning, the Netherlands in 2003 said that it was not the state of registry or the launching state with regard to those satellites, I guess on the theory that they had been delivered in orbit, but it did say that it was the responsible state and the state responsible for exercising jurisdiction and control under Articles 8 and 6 of the Outer Space Treaty. So I think we can see from this that different states have different views of how their obligations relate to transfers in orbit. And so if there is an accident in outer space, it's quite possible that different states are going to have different views of who should be liable. Now, there's currently, or as of 2010, there were over 20,000 non-functional objects which are being tracked by the U.S. government. That's excluding operational satellites, so bits of satellites, non-functional satellites. The number has, of course, grown since then. And so we need a general rule. Any specific item, any specific thing that might result in an accident is not necessarily something there's anyone paying attention to who was originally involved with its launch. It's being tracked by the U.S. government, it's being tracked as a safety hazard. The original companies may not be that involved with a lot of these items, and there may not be much of an incentive to hash out an agreement as to who is liable, who is responsible, and who should be exercising jurisdiction over all of these non-functional items, which under the treaty, according to the treaty, somebody is still liable. And so there really needs to be some sort of a general resolution of this. I would prefer that there be a new treaty. As far as I'm aware, there's just not support for that. I would prefer a treaty which addressed liability and registration together and attached liability to registration, allowing for transfers of registration like we have in aviation and high seas. Now those two aren't, aviation and high seas are not exactly the same as each other, but they're both superior to the unclear situation we have in outer space. Now, another way would be to do amendments. Now, if we can't do that, which right now I think most people assume we can't, we could amend the liability convention, the registration convention, and connect the registration, allow for it to be transferred, and make that the thing which attaches jurisdiction, liability, and responsibility. But failing that, Article 3 of the Liability Convention does still give us that out. So we could just be very clear at an international level to have some sort of statement that if you note to the UN or you give a declaration to the UN that you're intending to take responsibility, then at least under Article 3 for damage in orbit, your state will not be held liable. There needs to be some sort of specific point. It's not enough to just say, well, ownership can shift, we accept that, because jurisdiction, responsibility, and liability can be completely separate from ownership, or at least they can be existing in a case where there's a wide variety of potential owners. There's a lot of complicated ownership structures which can exist, and typically, if somebody buys an interest in aircraft or a ship, that doesn't necessarily mean that there's a new flag or a new state of registration for an aircraft. So that's my recommendation. Preferably a new treaty, but failing that, states can be just very clear that there is some ability for the liability to shift the liable state to shift, at least as to damages in orbit. That is my argument, and I'll be contacted there. I don't know if I assume you have time for questions.
I have a question about the simple phrase launching state. I can imagine that to be something that is an active thing, like the state which actually causes the rocket to take off the Earth's surface. That would be something that would be an action unrelated to the geographic location. I can also imagine it to mean, what if the ESA has an island in the Caribbean that's not in their, it's a separate country down there. Is the launching state Grenada? Is the launching state the European Space Alliance? What if it's got a NASA, payload on it? What does the launching state mean here? And of course, maybe it's controlled completely by another entity once it gets up to orbit. And I just don't understand at all what the term launching state really means.
Right. Well, I think if you're going with the most straightforward interpretation of the treaties, it's just all of the above. Because it's procured for launching, if it's from a facility, it's the launching state, if it's from the territory. Those are all the launching state, and they're all jointly and severally liable under the treaties, which seems like a very undesirable state of affairs. Like it could potentially discourage a lot of activity if you're a poor equatorial state that's prime real estate, and there's a lot of states which would have to launch off of equatorial territory, and that state may not want to assume all the liabilities which are potentially attaching to the territory from which the object launches.
And some big companies have said they really want to launch off the high seas outside the state boundary. So they're launching on the high seas or from an aircraft into space.
Right, so that was a problem with sea launch. There was, I think, it took a while for all the states who were potentially implicated to realize that they were all implicated. And if it's being launched from a ship that has a certain national flag, I think there's a case that nation is on the hook. And in any case, there's still going to be a state that the nationals of the corporation are associated with. So there's at least going to be one state, even whether it's launched off of an aircraft, the aircraft's going to be registered, the ship's going to have a flag. There's going to be at least one state you can consider the launching state.
But all those things said that state is supposed to retain control. And that state quite often doesn't, because another country is launching from that location. So to me, this seems to be all nasty, mixed up, horrible.
It is, and a lot of when the liability was passed, it was very much on maximally protecting victims. There was kind of a given for exchange where the Outer Space Treaty was passed. The Outer Space Treaty was considered more advantageous to the space powers, and there were states who said, we're only going to pass the Outer Space Treaty domestically if you give us the Liability Convention. And so liability is fairly maximalist, and I think reassuring the states was maybe a higher priority than making sure that the system made sense. I mean, there's a lot of political stuff you see in the negotiation. Like, there's one period where a bunch of the communist states are denouncing the Vietnam War, just even though it's not the subject at hand. And so there were a lot of political considerations that maybe drowned out this kind of basic issue of having some sort of rational system of nationality.
As far as transfer liability, I know it's pretty broad. Why can't you just insure that? Why, as far as transferring risk, why can't you just take out a policy and say, if this happens, I know I sold it to you, I'm on the hook, you're going to indemnify me or something like that?
States can do that. You're probably upping the premium cost by not having as rational a system if there's not clarity as to who's on the hook.
It seems to me one reason that they might have removed the transfer of liability is that you could use it to try to shield yourself from risk. So, like, I launch a nuclear reactor from the United States, and then after 20 years, I transfer it to a company registered in Liberia, and then soon after it explodes, and I say, ha, not my problem, I transferred the liability. It's Liberia's responsibility.
And that could be
except they can't pay for anything.
That could be a problem, though. I think Liberia would have an incentive not to do that because liability under the space treaties is clearer than on the high seas. Also, if we're worried about flag and convenience issues, we need to keep in mind that the U.S. actually enabled that with regard to Liberia. The U.S. was a former Secretary of State, helped create that law. So the flag and convenience on the high seas was supported by U.S. policy because you had a desire to have certain ships that were protected or potentially controllable by the U.S. that were not inside U.S. jurisdiction. And so in aviation, they mostly avoid that issue. So I think it is largely an avoidable issue, at least to the degree we have it on the
Okay, great.
Without naming names, what do you think the biggest stumbling block is to putting together a new treaty or amendments to existing treaties? Does it rhyme with Russia, and how do you get past that?
No, I don't think that's the problem. I just think I think that's part of the problem, but it's more just uncertainty as to what would be passed, and people have other priorities. Is one of the other talks. And people have other priorities, and there's a bit of as far as the people for whom this is the top priority. If it's somebody's top priority, they don't necessarily trust the political figures in their country to make it enough of a priority to make sure things don't get messed up worse. I think. I'm sure people deserve to really do more about that. Let's see. Do we still have time?
So please for help.
Okay, two more questions. Okay, let's start with over there.
Fault was one of the words that was mentioned in there. Is there a clear definition of what fault means and what happens if you get it to small pieces, like that determination of fault in a particular issue that might rise to liability?
I think you would just go back and look at other international arbitrations and see how fault was treated in there. I think you do see some of these issues do come up in the negotiations. For example, causation does come up. People were saying it should be Anglo-American, basically Anglo-American proximate cause, and you can look at that's in the negotiation of the Outer Space Treaty, and you can look at a lot of other international court cases and see how fault was treated. And I think negligence would be a form of fault. We can see that in some international court cases. Let's go with a closer one.
How much impact do you think precedent will have when incidents happen that are in these gray areas, these ambiguities, on future law? Like, if it's settled in court now, do you think that will have much bearing on other similar incidents?
I think so, but it's hard to predict. I guess if it seems to work, then yes. If it